After Casey, abortion opponents continued to push for state and federal restrictions on abortion that would test the limits of Casey's undue burden standard. Some of this activity focused on late-term dilation and extraction, or DNX abortion procedures, that opponents called partial birth abortions. A Nebraska law prohibiting DNX procedures without an exception for the mother's health was struck down by the court in 2000 in Sternberg v. Carhart by a 5-4 majority that included the liberal justices and Justice O'Connor. Justice Kennedy, however, dissented, noting that Casey is premised on the states having an important constitutional role in defining their interests in the abortion debate, and that states may take sides in the abortion debate and come down on the side of the unborn. In Gonzalez v. Carhart, decided in 2007 after Justice O'Connor had been replaced by Justice Alito, the court upheld the Federal Partial Birth Abortion Act of 2007. Writing for a majority that included Justices Roberts, Scalia, Thomas, and Alito, Justice Kennedy distinguished Sternberg based on the wording of the different statutes. The federal statute defined a partial birth abortion as an abortion in which the person performing the abortion A. deliberately and intentionally vaginally delivers a living fetus until, in the case of a head-first presentation, the entire fetal head is outside the body of the mother, or, in the case of a breech presentation, any part of the fetal trunk past the navel is outside the body of the mother for the purpose of performing an overt act that the person knows will kill the partially delivered living fetus, and B. performs the overt act other than completion of delivery that kills the partially delivered living fetus. The definition in the Nebraska statute at issue in Sternberg referred to delivery of a living unborn child or a substantial portion thereof. According to the court, this meant that the federal statute prohibited only one limited kind of procedure, a late-term intact dilation and evacuation, leaving open the possibility of other procedures for late-term abortions. Further, the federal statute included an exception for a partial birth abortion that is necessary to save the life of a mother whose life is endangered by a physical disorder, physical illness, or physical injury, including a life-endangering physical condition caused by or arising from the pregnancy itself. Justice Kennedy's majority opinion includes a graphic description of the intact D&E procedure, which I will not rehearse in this video because it can be quite disturbing. If you're interested in more detail about how the procedure was described, you may want to retrieve the opinion in full. In her dissenting opinion, Justice Ginsburg questioned at least some aspects of this description and of other parts of the legislative record. Again, if you're interested in this, take a look at the full case. The court upheld the federal statute against a facial challenge while leaving open the possibility of an as-applied challenge in a later case. According to the court, the statute does not on its face impose a substantial obstacle to late-term but pre-viability abortions. Echoing his dissent in Sternberg, Justice Kennedy stated that the government may use its voice and its regulatory authority to show its profound respect for the life within the woman. Justice Kennedy further thought the ban on this procedure justifiable because, he said, it seems unexceptionable to conclude some women come to regret their choice to have an abortion, including possible severe depression and loss of esteem, and the state has an interest in ensuring so grave a choice is well informed. Finally, he argued, the ban does not present any particular health risks to women because other procedures are available even for late-term abortions. Justice Ginsburg filed a spirited dissent, joined by Justices Stevens, Souter, and Breyer. According to Justice Ginsburg, the court has consistently required that laws regulating abortion at any stage of pregnancy and in all cases safeguard a woman's health. The restriction here, she said, is unrelated to the woman's health and saves not a single fetus from destruction. And Justice Kennedy's comments about depression and loss of esteem are merely an anti-abortion shibboleth. Our final abortion case is Whole Woman's Health v. Hellerstedt, decided in 2016. At issue in Hellerstedt was a Texas statute that required facilities providing abortion services to qualify as surgical centers under state health regulations and to employ doctors with hospital admitting privileges. To understand these requirements, you need a little background in health law. Hospitals, as you might imagine, are heavily regulated by the state and federal governments. As part of that regulatory milieu, hospitals must exercise some supervision of the doctors who admit and treat patients in the hospital. Not just any doctor can admit a patient to any hospital. Most hospitals extend admitting privileges to select doctors who are considered part of the hospital's medical staff. This does not necessarily mean those doctors are employees of the hospital, but it does mean they have completed a rigorous accreditation process. If a doctor does not have admitting privileges where the patient is set to be admitted, the doctor must consult with another doctor who does have such privileges. A surgical center or ambulatory surgical center is a facility that is not a hospital at which same-day surgical procedures can be conducted. For example, if you're having a precancerous skin mole removed under a procedure that does not require an overnight hospital stay, you might have the procedure done in an ambulatory surgical center rather than a hospital. Ambulatory surgical centers are also heavily regulated, but their regulatory requirements and the range of services they may offer differ from those of hospitals. Usually, an ambulatory surgical center must either have a written transfer agreement with a nearby hospital, or all the physicians at the surgical center must have admitting privileges at a nearby hospital, in case a same-day surgery patient faces complications that require an emergency hospital stay. The economic rationale for allowing ambulatory surgical centers is that they allow a wider range of procedures to be locally accessible at a lower cost than centralizing all procedures in a hospital. With this background, you can see the rationale for the Texas statute at issue in Hellerstedt. Proponents of such regulations argue that non-chemical abortions are surgical procedures, and that even chemical abortions, i.e. the morning after pill, are invasive and involve medical risk. Opponents of such regulations, who call them target regulation of abortion providers or TRAP statutes, claim that most abortions are procedural rather than surgical because they are performed through the cervix without an incision, and that surgical type regulation is excessive. Hovering behind this dispute is the fact that many abortions are provided in clinics or women's health centers that are not qualified as surgical centers. This does not mean, of course, that clinics or women's health centers providing abortion services are entirely unregulated. But they may be regulated like retail walk-in health clinics that treat low acuity conditions such as colds and the flu, or like freestanding doctor's offices, all of which were at best lightly regulated prior to regulations prompted by the growth of clinics and doctors providing outpatient abortion services. Looming even larger is the role of the nonprofit organization Planned Parenthood in running many of these outpatient clinics, and the government funding that goes to Planned Parenthood, largely through Medicaid reimbursement of services provided to low-income patients, including services such as pap smears, HIV tests, and contraceptives, as well as abortions. Proponents of abortion clinic accreditation or TRAP laws undoubtedly want to limit Planned Parenthood's role and limit easy access to abortions by imposing surgical center regulations on abortion clinics. In Hellerstedt, a liberal majority struck down the Texas statute. In the majority opinion, Justice Breyer stated that neither the surgical center nor admitting privileges provisions confers medical benefits sufficient to justify the burdens that each imposes. Further, Justice Breyer noted, evidence at trial shows these provisions are unnecessary and that the admitting privileges requirement led to closing of half of Texas's abortion clinics. In a concurrence, Justice Ginsburg stated that laws that do little or nothing for health, but rather strew impediments to abortion, cannot survive judicial inspection. In dissent, Justice Thomas suggested that the majority had applied a general benefit versus balancing test and that the undue burden test announced in Casey should be read more like a form of strict scrutiny. In another dissent, Justice Alito stated, contrary to Justice Breyer's conclusion, that the record at trial did not suggest that Texas law should be held facially invalid. So, after Casey, Carhart, and Hellerstedt, have we reached the end of abortion jurisprudence? Not by a long shot. Legislative efforts and litigation continue apace. There are literally hundreds of lower court cases since Hellerstedt involving different aspects of abortion restrictions with varying results. Whether the new conservative majority on the court ever overrules the core principles of Roe and Casey or hews to some concept of stare decisis remains to be seen. But you can be sure that further issues will arise and that at the very least the present undue burden test will be further glossed or modified. And even if there is a significant change in constitutional doctrine, the battle will intensify in the legislative arena. For now, the basic constitutional doctrine is that, under Roe, the right of privacy recognized under the due process clauses of the 5th and 14th Amendments includes the decision whether to have an abortion. Before viability, the government cannot deprive a woman of access to abortion outright. And under Casey, a statute or federal limitation on access to abortions must meet an undue burden test. However, the government interest and potential burdens under such a test might be defined.